Priyanka, cause list, nothing is here. Looks like the court is not yet ready. I don't even have a cause list in front of me today. Thanks. Yes. All right. Just wait for the matter to be called up. It's item number 1. Mr. Mahanta, Mr. Borwa, no mention for old matters and orders matters. Very good. So you want to withdraw item 11? Wonderful. Item 11. Heard Mr. P. Borwa, learned counsel for the petitioner. Stop. Also heard Mr. A. Sharma, learned SC Oil India Limited. Stop. Mr. P. Borwa, learned counsel for the petitioner, submits that he has received instructions from the petitioner not to press the writ petition. Stop. Accordingly, he seeks withdrawal of the same. In view of the aforesaid endorsement made by the learned counsel for the petitioner, this writ petition stands disposed of on withdrawal. Interim order passed any shall stand vacated. Well, to 7 থাকিব. $25 supplementary. Yes, what do you want in 25? Are you objecting to the adjournment? And simply say that you are submitting so many things, I thought you are objecting. You see, judicial time is very valuable. If you are also, if you are consenting to the adjournment, then say that, and you want a date, definitely a date can be given. As prayed for by MS H. Das, learned counsel for the respondent. Respondent number 1 and 2, with consent from the petitioner, list this matter on please sort it out. When do you want it? June 2024. Next, call the list.
Daily list for admission.
Yes. The affidavit has been placed. Yes. Mr. Chetri, which order are you drawing my attention to? Yes. There was a specific query which was put to Mr. Mohanto, respondent, whether a right of way to the petitioner. Yes, you have the instructions. No. That will be open. Here egress ingress was what was sought for. Your entry was restricted. Now they are opening it 50%. We will open the gate. So then does that addresses the issue? So you are satisfied? In view of that averment, can this matter be disposed of? But do you need his presence if the matter can be disposed of? You are the petitioner. If you are satisfied, then why do you want the presence of the senior counsel for respondent? Huh? Well, but Mr. Counsel, there is nothing adverse that this court is passing against you, that you want your senior to be represented. You have filed an affidavit. In terms of the affidavit, the petitioner seems to be satisfied. Then nothing remains to be adjudicated. I am not passing any order. Yes, Mr. Chadwick, in that view, can this matter be disposed? Where is the affidavit? Page 88. Which paragraph in the affidavit? Yes, I have it. Yes, Mr. Chetri. It is possible to give right of way to the petitioner through the land of this deponent after proper measurement for the road. So also there is a condition that you will hand over some portion of land from adjacent land on which the petitioner has seeking settlement, as because the deponent has paid so and so. So you are agreeable to this? Anything from the affidavit of the district commissioner? Nothing. Mr. Talukdar, just 1 second. But the prayer of your petition is something different, Mr. Chetri. If you see, this court may not go into all this now. If you are satisfied with the respond of the affidavit, in that term, this court can say it has become infructuous. All right? Right away. Who is respondent number 5? District Commissioner. Anything, Mr. Talukdar? All right. Okay. Very well. Item number 1. Heard Mr. B. Chetri, learned counsel for the petitioner. Also heard Mr. B. Talukdar, learned senior counsel, assisted by 4, 5, 6 and 7. And Mr. B. Chetri assisted by your junior's name? So, by way of this writ petition, the petitioner is seeking direction to the respondent authorities to dispose of the representation of the petitioner dated 25/5/2015 and 26/11/2016, taking into account the genuine purchaser of 1 bigha land under DAG number 417 and AP number 26 in Medamgao under Beltola Moza, and or settlement to the petitioners to the remaining part of the land as landless person in terms of Government Land Policy 1989. Stop. Today, when the matter has been called, comma, it is submitted by Mr. B. Chetri, Learned Counsel for the petitioner, that in the affidavit in opposition filed by the respondent number 5 within bracket District Commissioner Kamrup Metro Guwahati on 6/2/2024, sorry, sir, not that affidavit. Where is that other affidavit which you had? No, that is not relevant. I think you had drawn the attention of this 22nd March 24 affidavit by respondent number 8 and 9, correct? Who is 8 and 9? Private respondent. All right. Mr. B. Chetri, ki likhis lo. Filed by the respondent number 8 and 9. No. 8 and 9 within bracket Parthojit Borwa and Manojdeep Das. In pursuance to the order dated 7/2/2024, has stated that it is possible to give right of way to the petitioner through the land of the respondent number 8 and 9 stop. He accordingly submits that in view of the aforesaid concession given by the respondent number 8 and 9 in their affidavit, comma, the grievance of the petitioner has been met and nothing survives for adjudication in this writ petition. Stop. One second. Just hear the order. Where is that 7/7/2, huh? That order? That order is 7/2. It appears that this court, by order dated 7/2/2024, has put a specific query upon the learned senior counsel representing respondent number 8 and 9 as to whether the private respondent would have any difficulties in giving a right of way to the petitioners if any allotment of the land is granted to the petitioner. Stop. It further appears that the respondent number 8 and 9, by filing affidavit on 22/3/2024, stated as hereunder. Paragraph 5. It's at running page 86. A green flag to us. Stop. In view of the endorsement made by the learned counsel for the petitioner, comma, this writ petition has become infructuous in view of the aforesaid. With what direction? Mr. Chetri, repeatedly this court had asked you if you are satisfied. You said you have been satisfied, and that is why this court is... Exactly, this is why I read out the prayers to you. Yes. Very well, I have read this. Now you see whether the government will give settlement or not, that is up to the government. No, orders cannot be just passed like that. You'll have to make out a case. It appears that you and the private respondent have resolved. But now whether you are entitled for settlement or not, that is a different aspect of the matter. Mr. Talukdar? Sorry, one second. Yes, Mr. Talukdar? So in that terms it can be disposed of? Anupam, এই অর্ডাৰটো তুমি মোক এবাৰ দেখুৱাই দিবা ভিতৰত টাইপ কৰা হয়। Yes. $23. $23.3. A lot of affidavits appears to have been filed. এখন ক'ত আছে চোৱাচোন মৃগাংক? Oh, I got it. 23.3.22. Yes, which paragraph? One four. Yes. According to you have filed these applications, which is reflected in paragraph 2 of this order. These are the two applications. So then let government dispose of these two applications. Right. All right. Command change hobo. First of all, DDI bhal niki. Third set kini kola no hai. First or third or episode ki bili likhila by way of this writ petition. Our next paragraph what like. Heard the parties. Stop. It appears from the affidavit on opposition filed on 23/3/2022 that by respondent number 5 within bracket District Commissioner Kamrup Metro, that as per record the petitioner had not filed any required documents which are mandatory for settlement of land in Greater Guwahati area as per present land policy and government instruction presently in force for settlement of land. Stop. It is the further case of the state government that the government has adopted new land policy of 2019 and new checklists are also adopted. Hence, if the petitioners submit fresh application along with relevant documents before the appropriate authority, the petitioner's case will be taken care to place before the next SDLAC meeting for consideration. Stop. It appears that that the petitioner has filed the affidavit in reply on 24/1/2023 against the aforesaid affidavit in opposition, wherein the petitioner has submitted that on 26/11/21 two applications were filed seeking settlement of the land measuring 1 katha 5 lecha each. The receipt numbers of the said applications are 13562 and 13561 dated 26/11/2021. Stop. It further appears that the land wherein the petitioners are seeking settlement, the entrance of the said land has been blocked by the respondent number 8 and 9. Stop. It further appears that this court, by order dated 7/2/2024, has put a specific query upon the learned senior counsel representing the respondent number 8 and 9 as to whether the private respondents would have any difficulties in giving a right of way to the petitioners if any allotment of the land is granted to the petitioners. Stop. The respondent number 8 and 9, by filing an affidavit on 22/3/2024, stated that it is possible to give right of way to the petitioner through the land of the respondent 8 and 9 after proper measurement for the road by the concerned revenue authority, and on the condition that the petitioner will hand over same portion, I think it should be some portion of land from adjacent land on which the petitioner has seeking settlement, as because the private respondent has paid premium of rupees 15 lakh for 2 katha 10 lecha of land way back in the year 2008, and they have been possessing the same. Stop. And the remaining 2 katha 10 lecha of the subject land is with the petitioner. Stop. There has been a consensus amongst the parties that this writ petition can be disposed of with a direction to the state government to dispose of the applications, to dispose of the application filed by the petitioner in accordance with the land policy of 2019. Stop. Okay. In view of the aforesaid endorsement made by the learned counsels representing the respondent, representing the parties, this writ petition, this court is of the considered view that this writ petition can be disposed of with a direction to the respondent number 5 to dispose, to consider the two applications being 13562 and 13561 dated 26/11/2021 filed by the petitioner in terms of the new land policy of 2019. Stop. This should suffice on next within a period of 3 months from the date of receipt of certified copy of this order. Disposed with the aforesaid observation disposed. Bill payment. Yes, you have handed over this illegible parawise comments. This morning. So you have given it before the matter is called. That will not do. You will have to file an affidavit because the other side has a right to rebut. What is your stand here? So then you file an affidavit. But what took you so long to get this parawise comment? It's a 2018 matter. The bill of the petitioner is pending since 2018. Please don't shift the blame. You all have taken over. Now it is your responsibility. Anyway, we will give you 1 week time. You file the affidavit. Mr. Your name? U. Sharma, Learned Standing Counsel. Learned Counsel for PNRD submits that he has received that the Standing Counsel PNRD's office has received the parawise comments to the writ petition, comma, a copy of which is also placed before this court. Stop. It appears from the aforesaid parawise comments that the respondents are disputing the bill submitted bill of the petitioner. Stop. Let the parawise comments be placed by way of an affidavit with copy to the other side. List this matter after 1 week on 24th so and so. Needless to clarify that the requisite affidavit shall be filed by PNRD without fail by the next date. A copy of the parawise comment is returned back. Please file the affidavit. Now you have the parawise comments. On that day, do not say that you have sent it for vetting. IOC? You are for the IOC? Yes, Mr. Gogoi, what is this matter? From? Affidavits have been filed? Yes. Yes. Yes, tell me. That locality thing. Yes. Annexure 1. 1 second. Just 1 second. So you are seeking quashing of the selection of R3. Who is appearing for R3? You are for R3. Because there has been some conditions. It has to be within the locality. He is not from the locality. That was your ground, right? All right. Just place the relevant documents. Yes. 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 Where do you get that? Yes. 13/7/18. Okay. All right. All right. Yes. 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 Yes, come to page 41. Yes, yes, I've seen. 20? Yes. Yes, Durgam. What does, this is the meaning of DKV? Yes, yes. So the meaning is that in these areas where it is not feasible to set up the Grameen and Rural Vitrak, in that situation, the LPG distributors will be called as DKV, who shall serve the LPG customers situated in those areas. Correct? And Rurban Vitrak is, what does Rurban Vitrak means? That is rural areas. Rural areas. And Grameen. All right. Yes. 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 Gram Panchayat. Then residing in the concerned Gram Panchayat or in the concerned revenue subdivision. Two, then two, otherwise three. Now here in your case the advertisement, Gao Panchayat is Shampur, and advertised location will be, no, Bilpar, I think. Bilpar, correct. Bilpar. So if there is no eligible applicants from Bilpar, then revenue subdivision. Now revenue subdivision is Dolgao, correct? Then Dolgao. No, subdivision. No, number one says eligible applicants residing in the concerned Gram Panchayat of the advertised location. So Gram Panchayat means Shampur. Sorry, you're right. So it should be Shampur. And if second says eligible applicant residing in the concerned revenue subdivision. Revenue subdivision is Dolgao. Correct? Eligible applicants not residing in the concerned so and so or in the concerned. What does this mean? All right. Yes. 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 How many petitioners are there? This is petitioner is from Gram Panchayat Shampur. So he is there. He's from the Gram Panchayat. Yes. And 70. Where is the application of the second petitioner? All right, very well. Page 71 is the priority list. Yes. Petitioner is MD Mafidul Islam. He is at serial number 6. And 2 is at serial number 3. Where are they from? 2 is from where? Shampur. So they are there. Okay. Okay. All right, noted. All right, noted, Mr. Gogoi. Serial number 1, 2, and 4. Now, you have made them parties? Serial number 3, there is no complaint. Serial number 4. And what about number 2? All right. So you had raised. When did you give the complaint date? It's a date 5/11. Very well. Now, what happened to your complaint? Are you disputing that? Are you saying that your complaint has not been processed, in terms of the procedure prescribed in that clause of guidelines? That is your case. No, but ultimately, the issue that appears, which is for determination, is whether respondent number 3 belongs to Gram Panchayat Shampur or not. Now, what is who is R3? Just one sec, Mr. Gogoi. IOC, you have done something, any inquiry or anything to find out where his residence is? Where is that? Where is that? Yes. Yes. Yes, next. This is 810. Since last 6 months. And he's studying at the land at the Sedgwick. Yes. Then what is your grievance, Mr. Gogor? Take your seat. Page 70. Seven. Yes. Yes. 68 Dolgaon. Gaon Panchayat, Baligaon. Yes. Any reply to this? Any explanation? No explanation to this. Yes. Yes, I have seen. 619. Yes. 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 No, that's all right. R3, yes. 28 February, yes. Yes. What does this indicate? Where is it all mentioned here? No, this purchase is of which date? Where? 12/7/18 is the order of the circle officer. Please read. What is the deed number? No, the deed date. Date. All right. All right. You have filed a reply against this. All right. No, you have filed a reply to this affidavit. All right, I understood that.
By particular circle officer, that circle officer issued a certificate and then decided 6 months.
That certificate is of the circle officer.
That circle. Extraneous consideration I cannot say but it's the result.
On 8/10/2018. 8/10. And this deed was of
12/7/2008. Date of Namdari 12/7/2008. Date is 2008.
just one second. Go slowly, Mr. Gogoi. Deed of sale. Deed is of.
This one was done from 2008.
Yes.
Last date of filing the application 2000 or 13,005.
All right.
And certificate was also issued by that particular circular saying that and was
Filed on 12th May. 12th May. Yes. This annexure 2010-20. No person in the name of Nikibul so and so is found. But this is of 2020. It appears in 2018 he has purchased a land.
Purchase the land. Purchase the land. Purchase the land. Last day.
No, whatever. But it appears that on that day in 2018 he has purchased a land. Correct. Then how this RTI says that no person in the name of Nebikul Islam is found? Yes. Yes.
Was by the public.
Hmm. Hmm. Yes. But if he is newly purchased land there and he started residing, then there may not be necessary that his name. Now the whole question is whether he is residing there or not. No, now that is not defined in that guidelines. Hmm. Where? Which decision? Give. Because that 41, the priority inter se, it says applicants residing in the concerned Gram Panchayat. Now what does this word residing would indicate? Show me. Anything else? I think facts you have already. Show me. Admittedly, he has purchased this land in the month of July 2018. That is an admitted position. How it has been done, not done, that is another aspect. Correct? But as per admitted position, he has purchased the land in the month of July 2018. Correct? Where do you get that last date in that? You said it was 13/7/18. Okay, correct. One day before. Now whether that would mean that he is residing or not. Yes, you give the decision and then let us hear the other side. Rupak. Yes. (22 to 27). Yes. Yes. So residence will have to mean something more. One may have lands in various places, but merely possessing land or having an apartment would not make him resident of that location unless it is shown that he is continuing living. Correct? That is the concept. In this case, the Aadhaar card or any other documents have been given. Nothing has been given. Alright, I have read this decision. Yes, I have already read it. That Supreme Court decision. Yes, I have seen it. Yes, give. Here also, that advertisement was before the sale deed, right? After the sale deed was issued, probably looks like the sale has taken place, isn't it? You are carrying that? Acha, this is Bhagwan Das. Paragraph? In Bhagwan Das, you are relying which paragraph? 19 to 13? Okay. Yes. Paragraph? What is the issue? Residence. Okay. And the other one? Yes. Sarah? All right.
Then proceed that judgment Mr. Khalsa and rely on the lawyers of the law. This was
Upheld. Yes. Yes, yes, yes. That's right. 7, 14 and 15. Why the petitioner has filed the writ appeal? Okay. Yeah, I've seen. Yes. Yes, I'm. All right. Because here you have, in this case, the applicant was not the only entitled. In that view, the letter of intent was not issued, correct? And the division bench did not interfere with that part. Even in your case, you are not the only. You are only saying that the selection of the R3 is bad because R3 is not a resident of that location. All right. Yes. No, but here. Very well. Very well. Noted. Yes. You will have a right to reply. We'll come back to you. We've heard you enough. Yes, Mr. IOC. Yes. 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 So you have, on the basis of the sale deed, you have decided he is a resident. Why no other identity card or anything has been asked for? Because ultimately it is you are the author of these procedures, correct? You are the person who's called for the distributorship. Now, when you are saying eligible applicants residing, that means one of the eligible condition is that the person that you select has to be a resident of that location, correct? That is your first priority. Only if it is not available, you will go to something else. Now here, how do you decide the issue whether the applicant is a resident of that concerned Gram Panchayat or not? Simply because he has a land there. That is the only criteria. You will not require any other certificates. You will not require any Aadhaar card, voter's identity card or anything. See, it appears that in similar fashion you have been selecting. But it looks like people, the applicants are taking advantage of this situation. So it is time that you need to change and ask for something more, because the division bench judgment is very clear. Merely because somebody purchased a land and that certificate itself shall not be a reason for considering he is a resident. There has to be something more. Which certificate? Come to that certificate. Come to that certificate. Come to it. Page 7. Now, on the basis of the other documents that have been shown, it appears that the certificate may be not correct. What have you taken? What steps have you taken to verify? You have not asked for the Aadhaar card. Have you asked? Have you asked any other documents of the respondent number 3 to indicate that he is a resident of this area, the Shampur Gram Panchayat? Merely because, you see, Mr. Counsel, you cannot simply say that there is a certificate of the Gram Panchayat and that is sufficient. You cannot ignore the other documents, especially when there is a grievance provision there in your guidelines under which they have filed a complaint. How have you treated that complaint? Show me that. How have you treated that complaint? That I have understood. You cannot improve your case. Considering the Gram Panchayat certificate, the circle officer certificate, and the land Jamnabandi which has been given, you have accepted him to be a resident. I have understood that. Now the second question is, when the complaint has been filed, indicating all this, bringing out to the notice that he is voter list somewhere else, correct? And there are RTI replies indicating that he is not a resident of here. What have you done? I just want to know that. Show me that part. I am not interested in what you are saying. Show me from records. What have you done after receiving the complaint? Please show me that. So this is your reply to the complaint. Now, when you come to the circle officer says since last 6 months. On what basis the circle officer has given that certificate when admittedly the sale date is of 12/7/18? On what basis the circle officer knows him personally? On what basis? There is no maybe here. It appears that even the IOC authorities has not diligently dealt with the complaint. It's a very mechanical reply that you have given. Simply because there are certificates of circle officer and the Gram Panchayat, you have accepted him to be a resident. You have not even bothered to ask for any other documents. You are the tendering authority. So all right, that is your submission. All right. Yes. Have you brought any other documents on record to indicate that you have been residing in Rampur for last 6 months? Where? Where? In your reply. One second. Let me go to your affidavit in opposition. When did you file this? 28th February. Yes. You withdraw. Yes. Where you are reading? Paragraph? Yes. How are you saying April 18? It was July. No, have you in any agreement to sale or anything? Have you brought in to show that any documents that you have brought in to show that from April 18 you've been residing there? Yes. All right. So this is your only reply. You are saying you have been residing since April 18. What do you have to say to the decisions? How do you distinguish the decision? Yes. What are these tax invoice? No, why are you handing over papers like this? Have you annexed them or you have not annexed them? Mr. Counsel, this matter is taken up for hearing. If you are relying on some papers, it cannot be just passed over to the bench like this. Have you annexed these documents? Then why are you passing over these documents like this? Yes. Yes, the same is not the position. All right. In this case, there was an inquiry on the basis of by the revenue authority, and they have shown that you are continuing. The issue is not that you can be resident of one locality. If you are a resident of this particular Shampur locality for more than 6 months or so, you can be. But if suppose you have, in a given case, if this court finds that you have, after the advertisement, you have purchased a land only to become eligible under a clause, that will not make you a resident. The word resident would imply that you are continuing. You may have 3-4 residents. So therefore there has to be some more materials on record to indicate that you are residing in that place. Now it appears that in this case the deed is of July, the one day before the final day. So that means after the advertisement you have purchased this plot of land. You have not shown any documents to take it otherwise, correct? And just because there are 2 certificates issued by the Gram Panchayat and the circle officer, the distributorship is allotted to you on that basis. This is the admitted positions. Now this court has to see whether this is sufficient enough to conclude that you are a resident of that area. That is the issue. All right. Correct. Residential house, we are not going to that, whether you are residing in that locality or not. Now that is the only question. So you have not placed any other documents to show that pre-July 18 you have been residing. Correct? All right. Very well. Yeah. Calendar. Hearing concluded. List on 21/5/2024. Yes. For passing necessary orders. For passing orders. Yes. State Police to CBI. State, you have said, has filed an affidavit. When did you file this affidavit? On 28/3. But on the last occasion, that is 2nd April, it appears that since the up-to-date status report in connection with so-and-so and so-and-so is of 29 February, let R1 file an affidavit indicating the steps taken in order to find out the missing son, who is missing since 18, and also indicate the status of investigation. Now, has anything been filed after this? That is not available on record. You have filed. So then that affidavit has to come on record. When did you file it? 10/5. Mr. B.B. Gogoi. Mr. B.B. Gogoi, learned additional APP Assam, submits that an additional affidavit in terms of the order dated 2/4/24 passed by this court earlier, has been filed on 10/5/2024. Stop. However, the same is not available on record. Let registry verify and place the said affidavit on record. List. List. 22nd. Tell them for appearance to Didiba. I think that information would be essential. The land was acquired for the circle office. How it was given to the petitioner? Can be, and later on part of the settled land has appears to be under the possession of the circle office. Yes, I think that is what you had submitted. Anyway, in that case, Mr. Nath, I think you I'll give you a short date. You indicate, clarify this position. But however, you see, this is a very old matter, and what we had noted is that there was no material indicating as under what procedure of law the circle officer's office is situated in some portion of the petitioner's land. That is the only issue, I think, right, Mr. Talukdar? That's some portion. No, now if assuming there has been a mistake, now something has to be done, correct? So you come out with a proposal then, Mr. Nath. If I do not want on the next date an affidavit saying that there has been a mistake. That will not be sufficient. Correct. Which appears there is a mistake, right? So now what is to be done? See, those things are not material any longer, Mr. Nath. Admittedly, a land has been settled in favor of the petitioner, out of which some portion of the land there is a circle of. It is under the occupation of the circle office, which cannot be. How did the circle officer take this land? If there has been a mistake, then you have to correct it and adequately compensate the petitioner. Mr. Nath, rightly, wrongly, land has been settled in favor of the petitioner. That has not been set aside, correct? In that situation, how can you say that has been wrongly given, even if assuming a wrong has been done? Something has to be done. You cannot keep this land under the occupation of the circle officer and deprive the petitioner when that land has been settled in his favor. Something has to be done. You have to adequately compensate the petitioner. You come up with a concrete proposal in your affidavit. I know. I am going to indicate that, Mr. Talukdar. All right. Mr. D. Nath, learned senior government advocate for the state respondent, submits that the petitioner's land is admittedly under the occupation, some portion of the petitioner's land is admittedly under the occupation of the circle office, concerned circle office, as indicated in the affidavit in opposition filed on behalf of the respondent number 5. Stop. As regards the query of this court by order dated 10/5/2024, Mr. Nath submits that he has received instruction that initially the land has been inadvertently allotted to the petitioner despite the subject land having been acquired for the circle office, allotted for the concerned circle office. Stop. In the year 1995. Stop. It appears that the allotment of the petitioner has not been set aside by the respondent authorities till date. Stop. However, it further appears from the pleadings that admitted position is that some portion of petitioner's land is under the occupation and possession of the concerned circle office. Stop. Since in view of the said admitted position, let the state authorities come up with a proposal to resolve the issue. That should be sufficient. That is what I have said. I don't want to say anything. Let them come up with a proposal, Mr. Talukdar. Yes, Mr. Nath, I'm not indicating all that. How much time, Mr. Nath? How much time? 2 weeks or so the date did you list this matter again on? Mr. Nath, you come up, you see, you have to treat this matter from a humanitarian angle also. From 95, it's alright, 31, let them come, they will take some time, Mr. Talukdar. June 7 June. 24. This is that fake encounter case. This argument is already completed. Yes. 2014 10 SSC. Yes. Yes, Mr. Sharma, anything? Yes. 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 That has not been done. Otherwise, it appears that these procedures that has been laid down in para 13 more or less has been followed. Magistrate inquiry has already been done. Now, in this case, that inquiry is under challenge. Now, how will a writ court go into that? Generally, you see when such kind of cases comes up, what is at stake is the accountability, right? So, but for that, some material prima facie has to be there, which shows that maybe there is some foul play. In that case, the easiest way is to direct a impartial inquiry. Now, here the magistrate inquiry appears that it was based on evidences. There are sufficient evidence which indicates that these boys had come part of the mob, and in order to handle the situation, first fire was opened in the air, and then is the post-mortem report there? Cut injury. Yes. And some compensation has already been made? No. So that is not. Three? Oh, which part, where is it, sir? $31 point? See, at first it has to be shown that there has been a police encounter. But the magistrate inquiry says it's not an encounter. Correct? All right. All right, councillors, I have heard you enough. $30 of the judgment? Yes. it also, you see, you have to, you see, at 31.3, you have to understand in what context this has been laid down. It is mentioned here only. The team conducting inquiry investigation shall at a minimum sake. So it's not necessary that if one of the parameters here is not there, the entire inquiry is vitiated. One has to apply judicial mind and find out from that magistrate inquiry if something is lacking. Now, you have already made your arguments. Now, let me pass the order. Mr. Counsel, there cannot be a rehearing. This matter was posted today only for Mr. Sharma to reply to the judgment that you had rendered on the had given on the last occasion. Yes, please take your seats now. Item number 24. Heard Mr. A. Roshid. Mr. M. Hussain, learned counsel for the petitioner, stopped. Also heard Mr. H. Sharma, learned additional senior government advocate for the state respondent, stopped. This is an by filing the present writ petition, the petitioner is challenging the inquiry report dated 2013 conducted and submitted by the respondent number 12 within bracket Executive Magistrate Kokrajhar on the incident of fake encounter committed by the Kokrajhar police on 24/7/2012, in which two persons, namely Tahar Ali and Ramjan Ali, were killed by the gunfire without any caution and in cold blood. Stop. The case of the petitioner in brief is that on 24/7/2012, the police personnel initially apprehended the deceased Ramjan Ali and Sahar Ali and thereafter killed the deceased by the police personnel with cold blood without any reason. Stop. How are they related to the petitioner, Mr. Counsel? How are they related to the petitioner? Paragraph? Yes, all right. It appears that the petitioner, number one, is the father of Tahar Ali, and petitioner number 2 is the elder brother of Ramjan Ali. Stop. The petitioner frequently visited the Kokrajhar police station to lodge FIR against the police personnel, but the officer in charge did not accept the FIR. Stop. Subsequently, on 1/2/16, the officer in charge, Kokrajhar police station, threatened the petitioners with dire consequences and also threatened to send the petitioners in the jail, showing as extremists instead of accepting the FIR. Stop. Accordingly, the writ petitioner filed the present writ petition seeking direction inter alia for holding. Counsel, your synopsis is not correct. The inquiry is of, you are challenging the inquiry and you are saying you want a direction for holding judicial magistrate inquiry. The magistrate inquiry only you are challenging. Why are you all not mindful when you all are drafting? Anyway. Yes, the prayer is there, but synopsis. That is. দিয়া এই ৰবা এই যে FIR কথা লিখিছিলো হেতু কাটি দিয়া তাৰপিছত লেখা that on 27/7/2012 the informant namely Fakhrul Islam has lodged an FIR to the in-charge Salkocha police outpost stating that last on 24/7/12 at about 8 am his younger brother namely MD Ramjan went to the market from home and he is missing from there. Stop. Accordingly, an FIR was registered as GDE number 508 dated 27/7/2012. Stop. On 27/7/12, the informant Somesh Ali also lodged an FIR stating that his younger brother MD Sohar Ali is also missing from the market, and accordingly an FIR with GD entry number 508 dated 27/7/2012 was registered. On 25/7/12 at about 11:30 p.m. the informant namely Anjan Pandit, Deputy SP within bracket P Kokrajhar, has lodged an FIR to the OC Kokrajhar police station to the effect that on 24/7/2012 an information was received in police station that a group miscreants armed with lethal weapon has entered into the village and started setting fire on the dwelling houses. Stop. The villagers ran away out of fear. Stop. Getting the information, the informant along with SI and other team members rushed to the place of occurrence, wherein the rowdy mob which was already there tried to attack the police party with an intention to kill and snatch away service rifle of the police personnel. Stop. Further, the mob fired towards the police party with guns. Stop. Upon seeing this, the police party resorted to fire with rubber bullets, and when the mob became more violent and some miscreants from the mob started firing with guns, in order to save the life and property and executing the right of private defense, police also resorted to effective firing, after which the mob dispensed. Stop. Later on, while searching the place of occurrence, two unidentified miscreants were found injured, lying on the ground, and they were immediately shifted to the civil hospital. Stop. Accordingly, FIR was received and registered as Kokrajhar PS case number 225 of 2012, registered under section 147, 148, 149, 447, 448, 353, 307, 436, 427 IPC, read with section 25 within bracket 1B of 27 Arms Act. Stop. In relation to the aforesaid incident, an inquiry was conducted by the Executive Magistrate, Kokrajhar, and the finding of the said inquiry report dated 20/12/2013 is put to challenge in the present writ proceedings. Stop. Mr. M. Hussain, learned counsel for the petitioner, submits that the inquiry report submitted by the executive magistrate is vitiated and therefore an independent inquiry by CBI is required to be ordered in the case. Stop. He further submits that the two civilians have been brutally killed by the police personnel, and therefore an independent investigation is warranted. Stop. Mr. H. Sharma, learned additional senior government advocate, on the other hand, submits that the magistrate inquiry dated 2012/2013 indicates that the two youths were part of an unruly mob which had opened fire upon the police personnel, and in order to control the mob in self-defense, the police had to open fire. Stop. He accordingly submits that the instant writ petition is without any merit whatsoever. Stop. Before where you have said submissions of M. Hussain, just add this. He relies upon the decision of the Supreme Court, of the Apex Court, in the case of People's Union for Civil Liberties and another versus State of Maharashtra, reported in 2014, Volume 10, SSC 635. Stop. And then last or follow. Mr. Sharma Jodhpuyar. He further submits that in terms of paragraph 31.16 of the Apex Court in the case of People's Union for Civil Liberties, within bracket Supra, comma, the Honorable Apex Court, while laying down the guidelines to be followed in cases of police encounter, comma, provided that in the event the family of the victim finds that the procedure in the allegations of police encounters has not been followed, can make a complaint to the session judge having territorial jurisdiction over the place of incident. And upon such complaint being made, the session judge concerned shall look into the merits of the complaint and address the grievances raised therein. Stop. He further submits that in the present case, no such complaint has been made to the territorial session to the jurisdictional session judge by the family members of the victim or by the petitioner. Stop. He further submits that it is abundantly apparent from the report submitted by the magistrate that this is not a case of police encounter. Stop. I have heard the submissions made at the bar and have perused the materials available on record. I shall just come back in 5 minutes. it appears from the records available in the from the available records that subsequent registration of the FIR, a post-mortem of the dead bodies were conducted on 25/7/2012, which indicates bullet injury and cut injury on different parts of the body caused by sharp weapon, for which the death has occasion. Stop. It appears that since (27/2012) there was ethnic violence between Bodos and Muslims in Kokrajhar district going on, and altogether 5,595 numbers of cases were being registered in different police stations of Kokrajhar. Stop. A huge number of persons were killed and injured in the incident, affecting 153 numbers of villages of the district. Stop. Seizures of available evidences were done in the aftermath of the incidents from the places of occurrence. Stop. One inhabitant of the affected village, Bamungao, Probin Narjari, had in fact lodged a complaint, which was lodged a complaint, which was duly registered by the Kokrajhar PS, case number 256 of 2012, registered under section 147, 148, 149, 447, 448, 380, 436 IPC against a group of Muslim miscreants on the same day. Stop. Besides the said case, a complaint was also lodged by Sri Anjan Pandit APS, the then Deputy SP Kokrajhar, Vide Kokrajhar PS case number 225 of 2012. Stop. Further, in the context of the aforesaid incident, a magisterial inquiry was also conducted by the then District Magistrate Kokrajhar, Vide Office Memo Number KMG 7/2013/5 dated 14/6/13. Wherein the District Magistrate came to the finding that, within quotes likhi, after careful perusal of the statement of the witness, materials in record and other relevant material, it is found that the two youths who were killed were the members of the violent mob who came to attack the village Bamungao during the communal riot going on in several parts of the Kokrajhar district. It is also evident from the statements recorded above that the police party had to open fire only in self-defense and in order to disperse the mob who were destroying the houses of the villagers. Close the quote. It further appears that during the aforesaid magistral inquiry, statements of family members of the deceased and of the villagers were also recorded. Stop. It appears from the statements of the villagers that the police party, in order to retaliate the mob, had to fire. Stop. It further appears that the two youths had entered Kokrajhar in spite of existing indefinite curfew imposed by the district magistrate Kokrajhar and joined the unruly mob and attacked the police party with guns and other sharp weapons, for which the police party had to open fire only in self-defense and in order to disperse the mob who were destroying the houses of the villagers. Stop. Next paragraph. Undoubtedly, in a given case where allegations of fake encounters have been made, comma, an independent impartial inquiry is to be conducted However, in the present case, comma, it appears that the two youths have not been killed in any encounter, but were part of the mob which had attacked the village and the police personnel. Stop. Further, it appears that in terms of paragraph 31.4 of People's Union for Civil Liberties (SUPRA), the magistral inquiry under section 176 of the CRPC has been conducted and a report has been submitted thereof, which clearly indicates that there has been no fake encounter as alleged in the instant writ petition. Stop. Further, it appears that the family members of the two youths or the petitioner further no comma. Be that as it may, in a given case, in terms of paragraph 31.16 of the said judgment, comma, the family of the victim and or the petitioner is entitled to make a complaint to the session judge, to the jurisdictional session judge, in this, if the procedures have been abused by the investigating officer, comma, stop. However, in the present case, no such complaint whatsoever has also been made. Stop. That being so, this court finds no merit in the writ petition, and accordingly, the writ petition stands dismissed, no cost. That is relatable to a fake encounter, and of course, if you make an application, it will be considered. Where has your application? You have not made it. Then, all right, next.
Delegating item 5.
Mr. Das, case diary available? Yes, Mr. Ganguly? But Mr. Ganguly, these facts were available with you. These are not changed circumstances. Second bail application is not a rehearing. Has any circumstances changed after the rejection? This can't be a review or a rehearing, Mr. Ganguly. Where is the rejection order? Yes, page 58. Yes. You are Anup. Orup or Anup? Anup. Yes, I have seen it. This is AB. There are so many allegations, everything was looked into, and accordingly AB was rejected. You have not been able to impress this court that there has been any change of circumstances. Please come to the point. Anything has changed after 11/3/2024? Annexure, page 24. Yes. By Zakir Oja? Yes. So what are you trying to draw home, Mr. Ganguly? He's the main accused. All right. All right. Anything else? Mr. Ganguly, this is not a rehearing. Yes. No, no. All right. Which two persons have been released on bail? Zakir Roja, that was a bail application, regular bail. Where is that order? What is relevant? You are not having it. All right. Sorry, Mr. Ganguly. Heard Mr. A. Ganguly, learned counsel for the petitioner, stop. Also heard Mr. D. Das, learned APP for the state respondent. All right, Mr. Ganguly. All right, please take your seat now. This is an application under Section 438 of the CRPC 1973 for granting pre-arrest bail to the petitioner I. Onup Oja, who is apprehending arrest in connection with Crime Branch PS case number 3 of 2024, registered under Section 120B, 420, 468, 471, 409 of IPC 1860. Stop. For second bail application. Pertinent to mention that by order dated 11/3/2024, this court, after taking the entirety of the facts and circumstances of the case and going through the case diary produced before the court, rejected the prayer of anticipatory bail of the petitioner. Stop. Mr. A. Ganguly submits that the elder brother of the petitioner, I. Zakir Oja, is the mastermind in the alleged land grabbing offense, and has executed sale deed on 9/6/2006 in favor of the petitioner. Stop. Mr. D. Das, learned APP for the state respondent, submits that there has been no change of circumstances warranting grant of anticipatory bail in the second anticipatory bail application. Stop. Heard the parties, peruse the materials available on record. Stop. There appears no change of circumstances warranting grant of anticipatory bail as sought for in the instant second anticipatory bail application. Stop. Accordingly, the application stands rejected.
What do you stay vacating?
21. What is challenged, Mr. Das? What has been challenged on this writ petition? For terminating your contract. Now, no, Mr. Das, before we go to that provision, you've heard what the... All right, then I'll pose this matter after 10 days. In the meantime, you also convey the instruction to your client, because this is what has come from the IOC, correct? If the matter can be resolved, you can... All right. All right, but there is some mistake you said. In the meantime, you correct whatever is to be done. As prayed for, list this matter after on no, it's not the date.
29th May.
All right. Another date. All right, Mr. Das. 27.
26th August.
Yes, Mr. Singha. 29/4/24. Concurrence have come. All right, fine. Mr. A. Chalia, Learned Counsel, appearing for respondent number 2, submits that pursuant to the order of this court dated 29/4/2024, comma, the sealing proposal, comma, the sealing proposal has already been submitted to the government, and the sanction amount is expected to be released to the petitioner immediately after receipt of FOC from the government. Stop. In this regard, a correspondence dated 14 May 2024 issued by the Deputy Director Secondary Education Assam Kahilipara is placed before this court, which is kept on record and marked as X. Stop. Prayer is not opposed by the petitioner. Stop. List this matter. Prayer opposed. In view of the above, list this matter again on. All right. You give a photocopy of this also to Mr. Singha. Yes.
So, yeah.
This is that quashing petition. It was heard. Was it part heard? After some, all right. You want it at 2? That would be better. Yes. There is a criminal petition also connected with this petition. Tagged. Yes. Item number 7 is quashing of FIR. Huh? Item number 8. In item 8, Mr. Bora is appearing. No, correct. That is because. All right. But what is this writ petition for? Respondent number 11. Yes. Page. Page 56. Yes. Yes. I have. Yes. Are conditions or information? Yes. These are informations which has to be submitted. Yes. Yes. Whose false? Respondent 11. Age, criminal antecedent, and what is the other one? All right. All right. Yes. 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 $58. Yes, 58. This page 40 document is of date. One 311. All right. All right. Hmm. 58. This is dated. What? Date. Yes. Page. Page 25. Yes. Nil. Yes. Nil. Yes. All right. Noted. Page. Yes. Yes. All right. Yes. Page 33. Yes. Chart sheet dated. (22/5/2000). Yes. Where is that? Where? 2009. Yes. You're not ready? Hmm. Hmm. Page. Hmm. Yes. Education qualification. Yes. You are building up a case on the basis of the pleadings of the criminal petition. Yes. Okay. Hmm. Hmm. Page. Hmm. Yes. Yes. Earlier it is mentioned Okonbora. This is what you are trying to show. So according to you, this is not his certificate. He'll fail. He'll fail. Alright, understood. Highlight. Once. Page number 18. Yes, Okonbora. Yes, you have shown already. And in the criminal petition affidavit is in the affidavit what has been shown. Yes, it says Okonbora Alice Okon Chandra Bora. In the affidavit he says Alice Okon Chandra Bora. Anyway. Alright. Alright. Writ petition has been filed. Yes. Yes. Yes, Mr. Bora. That FIR you are seeking for question? Page? Yes. Yes. Yes, please. For which he has filed an FIR. In fact, this was the anxiety going in the mind of this court, that what is the relief, even in a situation if this court comes to a finding that it has been wrongly submitted, then what relief can be given at this stage? The FIR has been registered. That investigation is going on. Investigation has been stated in that criminal petition. So, where is the prayer? Just certiorari for what? Yes, what is this prayer? No, not has been omitted in the court's file. Shall be taken. I have not understood the prayer. Yes, Mr. Counsel, what is the prayer? Can you enlighten this court? What action? What action? Where is it given? As per law, what according you are the petitioner, you are complaining that action has not been taken. According to you, what action is to be taken? For that, you have already filed an FIR. That FIR has been registered. It is going on. What is to be done in this writ petition? Very well. Now, Mr. Counsel, as of now, admittedly, that the investigation in that FIR is going on, correct? And ultimately, this court has stayed it. That is why, otherwise, it has been registered. So that is a different aspect. It has been already, you have filed a complaint, action has been taken. Then what remains in this writ petition? And as appears that the only remedy could have been to cancel the nomination. In case that is also over, then what remains to serve? That's all right. For that, an FIR is already been filed. In this writ petition, I don't think anything survives. We can dismiss this writ petition as being infructuous. The rest of the matters can be heard. This is item number 7. What is this miscase? It's still pending. Is it pending or it has been disposed of? Anyway, in item number 7, heard Mr. L.K. Bora, Learned Counsel for the petitioner. Stop. Also heard Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr. J. Patwari and Mr. H. Sharma. You are there? Learned Additional Senior Government Advocate for the state government. Stop. You are also there? Okay. By filing this writ petition, the petitioner is seeking direction for taking appropriate actions against the respondent number 11, who is alleged to have submitted false information while filing his nomination paper. Correct? Stop. Heard the parties and so and so. Admittedly, an FIR has been filed in respect by the petitioner in respect of the alleged allegation that the respondent number 11 has filed false information while filing his nomination paper, which has been already registered. What is the FIR number? Which has been already registered as Bokhista PS case number 499 of 2013, registered under section 468, 420, 471 of IPC. Top. It further appears that the aforesaid FIR is put to challenge by the respondent number 3 in criminal petition number 614 of 2013, wherein this court, by order dated 16/8/2013, has suspended further proceedings in relation with the aforesaid FIR. Stop. Mr. Bora, where is that? You just showed that part, that remedy part. Yes. It further appears that in terms of the Election Commissioner's order dated 27/3/2003, the remedy provided for furnishing of any wrong or incomplete information is either for rejection of the nomination paper or inviting penal consequences under the IPC. Stop. In the present case, as stated above, the FIR has already been registered by the state authorities in connection with the allegation of furnishing wrong information while filing the subject nomination paper. Stop. And here in this case, this person had won the election and his term is also over. It is submitted at bar that the respondent number 11 has already served his term way back. I think it is enough to just say that has already. That is all right, but you see, right now, what remedy can be given to that? He has already served his term. Has already served his term. Stop. Being that, this court is of the considered view that the instant writ petition has become infructuous and has become infructuous. Stop. Accordingly, the writ petition stands dismissed as infructuous. Any miscellaneous or interlocutory application, if pending, is also shall also stand dismissed. And when do you want the criminal petition? There is another part, third matter fixed of Mr. K. N. Chaudhary. That will take some time. So another date, Mr. Bora? Yes, when? You can next week. Both matters. Next week, any day. You want a Tuesday? In the criminal petition, as prayed for, list on so and so. Okay.
What happened?
Why was the matter posted today? Other side also, I believe, had argued the matter.
Yes. Actually, basically, our understanding was we will submit our written argument. That we have prepared. I'll just briefly indicate, my lord. The complainant...
This is by 419-406-420.
Yes.
If I recollect, you were trying to make out the case that none of the ingredients...
Actually, neither there is any entrustment. So when there was no entrustment, where is the question of misappropriation?
Correct.
And as far as
420... For a 419, it has to be first an entrustment.
Yes, first for 406. Yes, there has to be entrustment. Then the question of misappropriation will come. The materials on record suggests that it was never entrusted. In fact, it was a case of transfer from principal to principal. The vouchers, invoices shows. And as far as 419 and 420 is concerned, there has to be an allegation that intention to deceit was there from the very beginning. That is not there. So the basic
Was the fact just...
Yes. Now, if a lordship, facts are like this, my lord. The complainant, they're allegedly they're actually in the business of manufacturing poultry feeds. Now, it's a Calcutta-based company, and their factory is in somewhere in West Bengal, in Darjeeling side. Now, they have appointed a consultant who is the petitioner.
In charge.
But the products that they're consigning, that is from principal to principal. They have their own godown at Sonapur. They have a godown in charge who used to receive the goods. Now the allegation is those goods were not accounted for. If it is not accounted for, hold up your own employee. Hold their own godown in charge. Now if a lordship should kindly come to the complaint, that itself will indicate the vagueness in the claim. Please come to page 37. I'll show from the complaint itself that there is no case. Please come to page 37. The first subpara.
You are for Deepshika Chaudhary.
Yes, Deepshika Chaudhary. The process maintained by us for carrying out our business through our Guwahati office was that Orders were procured by Guwahati office and were sent to Kolkata head office with detailed name of the customer along with his address items to disperse with rate. Head office used to issue delivery order for dispatch of goods from Raninagar plant Jalpaiguri to the godown located at Sonapur, Guwahati on the basis of the order raised by the Guwahati office. Sri Nilang Kashyap on several dates, the husband, Nilang Kashyap, till 23/6/23 communicated orders of different poultry commodity. I am not Nilang Kashyap, I am Deepsika. The goods so transported from our factory to Guwahati, stocked at our godown located at Sonapur, were supposed to be sold immediately to the customer against whom the orders were booked by the Guwahati office. Now this is important. The stocks were received in the godown by one of the employee of the Guwahati office, namely Bhavan Pathak, who certified that stock worth so-and-so, poultry feed in stock in so-and-so. This stock was supposed to be sold on or before so-and-so itself, but was surprised as there was no request from Guwahati office for issue of invoice to the consumer and neither was any indication of payment against this same. Then please come to the next page. Third line. We doubted some foul play and accordingly we all of a sudden made a surprise visit on 24/6/23 at Sonapur godown to take a stock of the stock supposed to be available in the godown as per the stock statement of Bhavan Pathak. We were surprised to find there was no stock of our product in the godown and Nilang Kashyap together with Deepsika Chaudhary were found absent. On being inquired, Bhavan Pathak, who received the stock, could not give any explanation in this regard. Kindly see, on being inquired, Bhavan Pathak, who received the stock. This is their own case.
Yes.
So where is the entrustment? And kindly see what is my role in the whole scene. Please come to page number 36. Sorry, 30. This is the document by which I was appointed. On top, scope of work. Consultant agrees to provide the services to the company in relation to their operations based in northeastern region. Then Lordships will kindly come to page number 33. Appendix
So I have
A.
been appointed as a
Consultant. Now what is my role, nature of duties? Market development or sale of animal
Where is
feeds.
that?
Page 33. Part of the same document. Market development for sale of animal feeds, liaising with dealers and salespersons, risk assessment of prospective dealers and stakeholders to act under the board of directors and be overall in charge of ethical norms of all employees of the company for operation. So these are the nature of duties I was supposed to perform. So by their own showing, the goods were dispatched from that factory in Jalpaiguri to Sonapur, where Bhavan Pathak was supposed to receive the goods. If in the process or
Goods were from
sent from Jalpaiguri to Sonapur.
Jalpaiguri to Sonapur.
Jalpaiguri is supposedly where the factory
Admittedly,
situates.
it was supposed to be received
Haan.
by
Bhavan Pathak.
Bhavan Pathak.
Yes. And I am the consultant. It is none of my duty to ensure sale. It is none of my duty to receive the sale proceeds and dispatch it to the company.
Yes.
So therefore, where is the question of
No
interest?
allegation also in the FIR,
Yeah.
correct me if I'm wrong,
Complaint.
in the complaint
Ah.
that the petitioner has been has received the goods or that the petitioner that there has been any entrustment. That is not there.
No, that is not there.
That is lacking.
Page 139. Sorry, page 39.
Yes.
Sri Nilang Kashyap and Deepsika Chaudhary have breached our trust and so stolen the goods from Sonapur godown. It now is clear to us that they and other director of Sonali Food Products have removed the goods and sold the same in market. Moreover, Bilty used as a proof of receipt of the transport
What
was
does this mean? That means the petitioner and Nilang Kashyap,
Ah.
they are director in another company by
yes,
the name of
namely
Foods.
Sonali Foods.
And these goods, which have been, which is supposed to have been received in the Gudam, has been transferred
Received by Sonali Foods.
by Sonali Food.
Now, that there, if your lordship would kindly come to page number 55. These are the delivery notes. Page 55.
Hudson Foods.
Hudson Foods, kindly see the consignor. Next column, kindly see consignee, Hudson Foods Private Limited. So from principal to principal. Please come to next page, page 56. Hudson Foods Private Limited is the consignor. Consignee is Hudson Foods.
No, but if I'm trying to just understand the allegation, this is the bill of supply, right?
Yes, delivery
the
note.
supply, the delivery was supposed to be from the Hudson Foods Private Limited to their
Go down at Sonapur.
from at Tepesia,
Yeah.
Sonapur.
Yes.
Right. But now these goods
Yeah.
have not been those was received by Bhaven Pathak
Huh.
in the Gudam.
Huh.
It has been sold to one Sonali.
Yes.
Is that the case? Which no, that's not the case.
That's not the case. My lord will kindly kahi document to dekhachila page code asile
119.
tahantor affidavit na.
What is the gist of allegation in the FIR?
Gist of allegation is there was an arrangement between the principal, that is the Hudson, with Deepsikha, that they will procure orders, remit it to the Calcutta office, they will send the supply, the goods will be sold, and the proceeds would be remitted back to the Calcutta. So that arrangement was interdicted because of unlawful intervention of the petitioner and Nilang Kashyap. In other words, their allegation is goods were dispatched, but they have not received the sale proceeds. When they did not receive the sale proceeds, when they inquired, they found that actually this is what is happening.
No, but where have the goods been transferred to? The goods.
That there is no
that
allegation.
that is not.
There is no allegation.
No, but Sonali Foods, you have said
Now I'm coming to that.
that allegation.
Yes. Please come to their affidavit.
So, Chaudhary, you are getting what this court is trying to ask.
Yes.
Yes. Page.
Page 117. It is Sonali Foods, na? Huh? It is?
Next, 119.
Now they have come up with this invoice.
Kundu
of
Carrying
course-
Corporation.
Yes, page 117. Kundu Carrying Corporation, that's the transporter. Now, if your lordship should kindly come towards the bottom, received 500 bags, okay. Has your lordship seen it? Somewhere in the bottom.
Yes.
Now there's a round seal.
Yes.
This is of Sonali Food Products. Now my lord will kindly come to page 119. 119 to Sonali. I got to 123. Huh?
Now 123.
No, 117 to carry to.
It was Sonali.
Please come to 119.
117.
Nine.
I don't think is Sonali.
Please come to 119, my lord.
Yes. Sonali Foods.
Sonali.
Receipt
Now kindly come to
123.
123.
Yes.
Kindly see. Receive 500 bags. Okay, this is Hudson Foods. Hudson has received.
No, but what about the other one?
No, my lord. These we say these are all fabricated. No, that is not even their complaint. Their complaint is the goods were sent to Sonapur office, but from Sonapur office, at best it's a case of theft then. If we go by the complaint, but the case has not been registered under 378. And this same person, at least with bare eyes, we can make out the endorsement regarding receipt is by the same handwriting. Prima facie, my lord.
Mr. Chaudhary, at this stage.
Yes, yes.
Difficult.
No, my only case is
You are right. Prima facie ingredients of 419, 406 and 420 is missing. Because there, even for 406, there has 419. There has to be a inducement.
allegation from the
Allegation of
very
cheating
beginning.
has to be there.
Those are not there.
Then only 419 can come. Right. Now that you are right, but be that as it may, this court will also have to see whether the allegations made in the FIR
Yes,
at all makes out any criminal offense.
yes.
If no, of course, this court shall exercise its.
My humble submission would be, my lord, after going through the complaint, it is the judicial authority which has cognizance করেছে do complaint do এ হয়েছে আমি কোনটা স্টেজে আছি complaint is it FIR আছে না complaint okay now charge sheet of course has not been filed, my lord. We have come against the
Exactly, that is
Huh.
why this is at the initial stage.
Stage.
We don't know.
No, if I can satisfy your lordship that the allegation taken in its face value, if we can make out that it does not constitute the offense in respect of which or under which the complaint has been lodged, then certainly lordship will come to the rescue.
No, but if suppose.
Yes.
You see, I'm being very fair. The Sonali foot stamp that is there,
Yes, yes.
rightly, wrongly fabricated, non-fabricated, but it appears.
Of course, the lordship cannot go to that extent now.
Correct. Now it appears that who are the director of that company, correct? So, and that allegation is there that Nilang Kashyap and you together have stolen these goods, and that voucher is there, which this court cannot ignore.
Correct.
Correct. That is the anxiety this court
No,
is
no.
feeling.
Then,
Otherwise,
no, I
as per
absolutely
419,
correct,
420
correct.
and 406,
No, my lord, if your lordship will kindly come to the case, case come to page 42.
yes.
Case has been registered under 419, 406, 420.
This is the FIR registration. Case is yet to be charge sheeted.
No, that is there, my lord. That I can't say that it is not there. At least they have brought on the materials on record. But prima facie, it is the same person.
Sorry?
Same person apparently received the goods. Somewhere they are using the seal of Hudson. Somewhere they are using the seal of Sonali.
That means something is
Of
there.
course, that is an aspect.
Something is there. And now whether Dipshika, that the petitioner is involved or not,
Yes.
that of course is too early right now, isn't it?
Correct.
Now, if the petitioner had no role in that company whose seal is FX,
Yes.
then of course this court would have, without asking
oh.
these questions, could
Right.
could have exercised the discretionary power.
Correct, correct.
But this fact that she is a director in that company cannot be ignored also.
Yes, yes.
And this company has received, and the sale proceeds has not been given to the company, principal company. Correct.
Yes.
These are administrative positions.
Correct. I could follow. So, in that case, I think that lordships can have an instruction from the public prosecutor regarding what is the progress of the investigation.
Is it
At this
still
stage,
like
what
that?
have they?
Investigation.
But there is an order of no coercive action to be taken, madam.
No coercive.
So what has happened to the investigation?
That's
Whether any forensic report is there regarding, my lord, those.
Any instruction as regards the status of the investigation? Charge sheet has been filed or not filed?
no, madam. No such as in fact.
But coercive actions doesn't mean that the investigation will not go on. Investigation is
There is no stay on the investigation.
investigation ought to have been completed by now.
Yes.
Only thing against the petitioner, coercive steps without
Should not be taken.
should not have
But
been
the
taken.
petitioner was not cooperative to the investigation agency, madam. He is not cooperative to the investigation. The petitioner, madam. I will show from the records, madam.
From showing from these records, what will happen? Steps should have been taken if the petitioner is not
That,
cooperating.
that argument is coming from the PP. My learned friend cannot say.
But admittedly,
I am submitting for the
even if
record
a
also,
given case of such, then they are not remediless.
Yes, ma'am.
Prosecution knows what is to be done in such cases if petitioners are not cooperating. Petitioner,
Lordship may ask them pointedly whether in respect of those invoices, let them have the instruction, my lord. Then Lordship will consider.
Yes, madam. This
Yes.
case is not as so easy as projected by senior counsel. Now, see, whether there is an element of criminal vicarious liability or not, my lord. Whether there is
Criminal vicarious liability will come later on.
how they did this.
Well, first of all, these offences, whether these offences at all can be.
It is not a case where only the petitioner is involved, my lord. There are 4 persons are involved, my lord. It is not a case where only the petitioner is involved in this case, my lord. There are 4 persons involved in this case, my lord.
Yes.
Deepsika Chaudhary's husband is also involved in this case, my lord. He was arrested, but he was forwarded to judicial custody, my lord. Bobon Pathak.
Thakur, right now, this petition this court is dealing with. So confine it with the petitioner.
Yes, ma'am.
If this court finds that there are no offence made out prima facie against the petitioner, then only in respect of the petitioner this court will exercise its
It is a
discretion.
case of petitioner.
Why are you submitting as a whole? This court is not concerned
Yes, ma'am.
with any other persons. They are not before this court.
Yes, ma'am.
So you show me what are the ingredients, what is the allegations against the petitioner,
Yes, ma'am.
whether those are sufficient for constituting an offence under
There is a
419,
prima facie case,
406,
ma'am.
420. Where
Yes,
is the entrustment number
Yes,
1?
ma'am.
Where is the inducement? Where is the deception? Show
I'll
us that.
show, ma'am. Now, kindly see, madam.
The demand, after demand they have not returned.
Yes, ma'am.
Because I think 406, a demand also is required to be made.
Yes, ma'am.
My lord, before my learned friend starts, my lord, my humble submission is, since we are confronted with those 2 invoices, my humble submission is Lordship would like to ask the PP to have the instruction on that. Then Lordship perhaps can take a call on the case. At least,
Before the matter, may I submit?
only
See, there's no point of hearing you right now because at the end of the day, if that is to be called for, because it appears those invoices are involved, where
that might implicate me.
if any investigation is done, if there is anything,
Yes,
let
but
this
this,
court be
but this is a
enlightened about it.
This is a consigning note, my lord, of the transporter, my lord, whether the petitioner is a director, my lord, one of the director, my lord.
Yes.
Normally, my lord, will the director sign the receipt? There will be somebody else in the office.
I'll show, my lord, from the records, my lord.
All right, you
Yes, ma'am.
you submit.
Now, ma'am, kindly see, my lord, whether the petitioner was discharging her duty, my lord, as a consultant or, my lord, to something else, my lord. Whether she was over in charge of the company of the Hudson Private Limited, my lord. Now, my lord, kindly see on 19/4/2021, my lord, the consultant agreement was executed, my lord, with the petitioner, my lord. And some scope of work has been assigned to him, my lord. Apart from that, my lord, the petitioner was entrusted to. For a moment, my lord.
Where is that interest?
Yes, madam. Now, kindly come to the lease agreement, my lord. Page 102, my lord, for my lord, objection, my lord.
Yes.
This is the lease agreement, my lord. Executed between one, my lord, Parakhmoni Bodo and Deepsika Chaudhary, my lord, representative of the Hudson, the respondent number 2 company, my lord.
Who?
Now, my lord,
Parakhmoni?
104, my lord, kindly see, my lord. Deepsika Chaudhary is the signatory of Hudson Food Private Limited, having administrative regional office so and so. She will be dealing in the products of Hudson Food Private Limited, and payment of lesser account will be made through the company account of Hudson Private Limited. But this scope of work is not included in the scope of work in the consultant agreement. That's why I am submitting. Apart from the scope of work, she was over in charge of the company. Bobon Pathak was appointed by the Deepsika Chaudhary, madam.
Yes. Yes.
Now, page 110, madam. This information was stated from a Minister of Corporate Affairs, madam. See, madam, date of incorporation 15/6/21. Sonali Foods and Feeds Private Limited. And next page, madam, Deepsika Chaudhary is one of the director, madam. Now, from 115 to 123, my lord, before the my lord, the 112, my lord, kindly see, my lord, these are Caesar list, my lord. The police seized the, my lord, these transporter consigning note, my lord. Now, 115, my lord, these goods has been, my lord, received by the Sonali Foods.
Yes.
It should be received by the Hudson, my lord.
No, at page 112.
115, my lord. 112 is the Caesar list, my lord.
Yes.
Now, 150, my lord, kindly see the.
Yes, this already this
Yes, my
court
lord.
seen Mr. Chaudhary had pointed
Because-
out. Yes. Now, you see, Mr. Borthakur,
Yes, my lord.
before proceeding further, I think let Mr. Das find out what is the status of the investigation. When can you have it?
Perhaps it's very maybe called for, because in that case she will find the materials so far usually collected.
All right.
In the case there will be
When?
Hathigao.
Hathigao.
Hathigao. It's from Hathigao.
Next week.
During the course of hearing, comma, it appears that the case diary is required looked into before deciding the criminal petition. Stop. Accordingly, let the case diary be produced on the next date. Stop. In the meantime, written arguments have been submitted on behalf of the petitioner, which is taken on record. Stop. List on.
It can be on 27th or 29th. Habo?
20.
Oh, then 28 or 30.
All right.
30.
30 on this one.
30, madam.
Yes.
30 for me, but there is a difficulty, my lord. But they are now on 4 or
Let it
6.
be on 3rd, madam.
All right.
It's a Monday.
All right.
3rd June.
It will, on record.
Monday.
In the meantime, Mr. Borthakur, if you want, you can file your on next date your written arguments also.
Monday. Monday.
But I can
Monday,
file today itself, my lord. I have made the ballot of
Then submit
Yes,
it.
ma'am.
Tade add Anupam. Tade likhi diba that written arguments on both on behalf of both the parties have been submitted.
Deep reference.
Same are kept on record.
Item 9.
Yes, Mr. Lahiri. Mr. Das.
Yes. May I please alert you? My lord, the issue here is,
For a long time.
yes, ma'am.
Yes, Ms.
This is a
Burman?
matter of 2014, my lord. Hope this gets over. My lord, the issue in this case is, my lord, a plot
No
of...
affidavit opposition file, no rejoinders.
No, my lord.
Quiet.
No, my lord. The state has admitted, my lord. The issue, the small issue is, my lord,
And compensation.
yes, the CRPF is in possession of our land, measuring about 5 bighas 4 lechas. Now we represented the matter, so nothing happened. So ultimately the inquiry was done. And now the deputy commissioner, the state of Assam, they have the circle officer also. They have surveyed the land, and they have come to a finding that this land is in the possession of the CRPF, and no acquisition or requisition has been done to that. Now the CRPF, they say that yes, it was acquired and given to them, but when the document was sought for by the circle officer, they could not produce anything. And even their affidavit, my lord, they have stated that these statements made in so-and-so are matters of record, but nothing has been annexed with the affidavit, my lord. Now, if your lordship...
According to you, which is also endorsed by the state government, is that your land has been acquired for the CRPF.
It has
No,
it has not been acquired. They are in forceful possession, my lord.
they are in possession without following,
following
the,
due process of law.
the procedure.
Yes, and
Is
there
that
are
correct?
judgments of the, my lord, Apex Court also, my lord.
on the similar in facts and circumstances, in what manner those things has to be done. And in one of the cases, our High Court also that, my lord, during national games, because of road widening, land was acquired, no compensation was given. So the writ petition was filed, and this honourable court had directed to pay the compensation. So in a nutshell,
Which is that Supreme Court case you have
my
referred?
lord, the Supreme Court cases, my lord, this is a case.
So land acquired, land has been
Land has been taken, my lord. Yes, my lord, without following.
procedure.
One, yes, my lord. One is, my lord, I am just giving the copy, my lord. This.
Rupa. Ms. Burman?
It's not the case of exactly forceful occupation, my lord. Though we are admitting in our affidavit that in the year 31/3/1975, the land in question was handed over to the CRPF authorities for their use, my lord. In joint survey reports, we have seen the occupied pattadars, my lord, in whose name this land was occupied. At that 2012, a joint survey was done after this matter has been initiated, my lord. So the petitioners in questions, they are happen to be the daughter of legal heirs so and so some, and in the occupation, my lord, we are finding different persons.
No,
And
the
secondly,
the
my lord,
circle officer says so, my lord.
no,
Yeah.
whatever is reflected in this affidavit and facts of
Yes,
the case, my lord,
yes.
I am placing that, my lord. I am not saying that it is
Of course,
right or wrong.
yes.
Secondly, my lord,
The record of right, somebody else's name
yes,
is there.
names are different. I have seen the joint survey report as well as the
This
documents.
is part
that-
of your affidavit.
Yes, my lord, they have brought the thing in. Joint survey reports are part of reading of petitioner's affidavit. I am submitting from that, my lord. The second thing is, my lord, at the time of acquisition, in some of the joint survey reports, it
Ms.
is.
Burman, one second. Mr. Das, if there is a dispute as regards to your entitlement, whether it is
Not
your
made
land,
party, my lord.
then
Those persons
yes,
concerned whose
then
name.
how is
No, my
this
lord, lordship will
petition
kindly see
maintainable?
that it is the report.
Be a disputed
No,
question.
no, no, lordship will kindly turn to, my lord, for a moment, page 30, my lord, 30. Where from my learned friend is submitting all those things, my lord, I don't know, because the
Page
record
30.
of the page 30, my lord. Annexure 6.
Submitting him from the joint survey report.
No,
Yes,
I'll
yes.
come to that, my lord.
Page
This is a
31
letter, my
is
lord,
as per
which has been issued by the circle officer, my lord, addressed to the additional DIG. I'll just read, my lord. With reference to the above subject matter, it is to inform you that on basis of complaint filed by so-and-so, 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 duly represented by their so-and-so in this office through the Deputy Commissioner Revenue, Kamrup, Assam, on being spot verification of this office dated so-and-so, on the land of the complaint by patta number so-and-so issued by the Deputy Commissioner, it is found that you have occupied
Reading
unauthorizedly
from page 31.
30, my lord. 30, Annexure 6.
Yes, you are found.
My lord, 1, 2, 3, fourth line, my lord. It is found. From bottom, my lord, first paragraph.
Occupied.
It is found that you have occupied unauthorizedly an area of 5 bighas, 4 kathas of land in dag number 5 and 49 of patta number 31 of your CRPF unit.
Indicate that there is this indicates
What is
that
the allegation?
Yes, I have understood. But this indicates that CRPF is illegally occupying a land.
Land.
Now the question which is arising right now is whether your land or somebody else's
That is
land.
also there. That is also there, my lord.
You are
I am
Yes.
trying to project that,
Right.
my lord, because I don't find their.
yes. Now,
Now your lordship will.
situation.
Yes.
The query of this court is how will this writ petition be maintainable?
Because from the, it is.
Joint survey report, it appears that it is doubtful whether the land is owned by you initially.
Let
your land or
her
not.
show, my lord, which joint
Whatever
survey
I
report
have
shows
read
it
out
is.
from the
Which page have
Which
you
page?
31, my lord.
Which page? 31.
That these are the report, my lord, regarding 50 bighas of land at the time of joint
Following
verification.
persons are found to be in possession.
Yes, my
Page
lord.
51. Your lordship will kindly.
According to you, petitioner's
31
name
that
is not here.
as
Five,
per
dag
available
number,
record, second
dag number
paragraph.
5 and 49. This is the
Which
one,
is the dag number?
5 and 49. Third, malab from top.
49. Yes, in the
Yes.
possession of CRPF.
CRPF. Now, this is. Then your lordship will kindly come to my.
Prior to CRPF,
My lord, in this petition,
Page
my lord, they have mentioned several ducks, my lord.
can you see? This is a matter which has been filed, which is pending since 2014, right?
My lord.
Now,
Well,
In a given case, if this land has been occupied by CRPF,
Yes, my lord.
then in that
We have admitted
situation, and if the
their
land
report,
belongs,
page 37. I'll just
last 1 second, and if the land belongs to the petitioner,
My lord.
in that situation, compensation has to be made.
My lord, but
One way out.
that
Why not
one-
case can this case not be disposed of with that direction
Yes, my
to
lord.
hold
My lord.
to cause an inquiry?
My lord.
And if petitioner is entitled, then he will be adequately compensated in accordance with law.
page
Because
37.
the allegations are serious, and coupled with the fact that you are also
Because I am stating on the
Correct.
basis of affidavit, my
Let
lord, as
the
we do not
concerned- let
have
the
any
district
record,
commissioner
my lord, to
decide
verify
everything.
My
who
lord,
is
it
the-
has already been
and-
decided.
and
Page
that-
37, my lord.
Page?
Page 37.
And probably that
Page 37. I'll take your lordship to
petitioner
two
said
more
that-
documents, my lord, from which it is the circle officer who is saying that it is our land, and the CRPF, page 37. Lordship got it, my lord?
yes.
Page 37. This letter has been, my lord, written by the circle officer, Sonapur Revenue Circle, and it has been addressed to the deputy commissioner.
Yes.
With reference to the subject cited above, I have the honor to inform you that as per letter under reference, the petitioner submitted by so-and-so regarding unauthorized occupation of CRPF for water pump house station was inquired into, and findings thereof, para 1, as per the record.
Number 1 is petitioner number. Charlene Nicola is.
They are three, my lord, three petitioners, sir.
Yes, yes.
Three
Who is P1? Charlene.
Yes, my lord.
And P2?
My lord, no, petitioner 1 is, my lord, this Criseda. Charlene is, my lord, second.
Wait.
And
Petitioner 1 is Criseda.
Criseda,
And P2?
Charlene,
And P2? P3?
Celeste.
3 petitioners.
Three
na?
petitioners.
Yes.
Now, as per record, land measuring 50 bigha so-and-so of dag number, all dag numbers of so-and-so stands in the name of, now your lordship will see,
I have seen. P2,
Charlie,
P1,
yes.
P3.
Yes. Then we'll come to, lordship will come to next para. Out of the land of 50 bigha, the original patta holders, namely Charlene, Criseda, Celeste, sold their land measuring so-and-so to Rakesh Rongpi as mentioned above. Number 3, as per LMSK report, out of the land measuring 5 bigha 4 katha of dag number 5 and 49, this is the disputed malo land, on patta number so-and-so, under the ownership of pattadar so-and-so, is occupied by CRPF putting water pump. Malo, where is the disputed question of fact? It is the circle officer who says that this dag patta land stands in the name of the petitioner and these lands are in the occupation of the CRPF. Then, my lord, next page. Later on, CRPF official requests the undersigned to fix another date for providing required document in regard to acquisition of land of water pump station. Accordingly, it was fixed on so-and-so. However, the office of so-and-so was unable to provide the document. It may be mentioned that as per the revenue record available in this office, there is no record of any order of acquisition or compensation of the said land used as water pump by CRPF. Then your lordship will kindly come to, my lord,
Yes.
page 47, my lord. This is a translated copy, my lord. Joint verification. What page 47, my lord?
Yes.
Yes. My lord, report regarding joint verification of land in presence of CRPF and Mondal of Land Acquisition Branch. With reference to the letter number so-and-so, I'd like to inform your honor that a joint verification has been conducted in the presence of CRPF officials and Mondal of the Land Acquisition Branch on the land covered by dag number so-and-so of
Right,
village
it's in
so-and-so.
the possession of CRPF since
Yes,
1990.
upon joint verification being conducted, it is found that the land measuring so-and-so and land measuring 5 bigha so-and-so are in possession of CRPF. As per the available record, the following are the recorded pattadars in respect of the total.
This does?
Yes, my lord. No, where from, my lord, my learned friend?
2013, that's Tukaram's case, which is the paragraph?
My lord, relevant paragraph I have highlighted, my lord, para 17.
Ms. Gorman, take your seat.
My lord.
Para
17.
17.
Yes.
Depriving the appellant of their immovable properties was a clear violation of Article 21 of the Constitution. In a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon them to rehabilitate such persons. The non-fulfillment of their obligations would tantamount to forcing the said uprooted persons to become vagabonds or to indulge in antisocial activities, and such sentiments would be born in them on account of such ill treatment. Therefore, it is not permissible for any welfare state to uproot a person and deprive him of fundamental constitutional and human rights under grab of industrial development. The appellant has been deprived of his legitimate dues for about half a century. In such fact situation, we fail to understand for what class of citizen the Constitution provides guarantees and rights in this regard, and what is the exact percentage of citizens in this country to whom the Constitution's statutory benefits are accorded and according with law. Then, Your Lordship, I'll skip those paragraphs and come to para 22, my Lord. Because
Here good sense prevailed.
yes, my Lord, that is why in this judgment has also been followed in the case of 2020, my Lord, that Vidya Devi. In Vidya Devi case also, my Lord, it has been followed, my Lord. 10.5, my Lord. But Vidya Devi is 2022 SCC 569. And in this Tukaram's case, my Lord, in para 22, the court has directed, because under the old act, first of all, there has to be section 4, then section 6, then section 11. The court said that it would be deemed, that all these publications have been carried out, deemed publications, and direction was given to.
No, but now in this case, nothing has been done.
That is why, my Lord.
Now then, what is to be done?
My Lord, the compensation, the deputy commissioner, because other case that, my Lord, our High Court judgment, my Lord, I have given, that in that case, following this Tukaram judgment, that is, my Lord, that this land was acquired, my Lord, by the PWD during road widening. Now, para 4, my Lord, the findings. That in view of the matter, the writ petition is allowed.
In this case, this court have directed to pay just and proper compensation in terms of LA Act, and also directed that formal notification of acquisition, etc., be issued in terms of Tukaram's case. This has been done.
Similar, my Lord, it is the deputy district collector who is to assess. Let the district collector, my Lord, initiate necessary proceedings for compensation, my Lord.
Where is the stand of the CRPF?
CRPF, my Lord, they have filed in 16/12/2014. Their basic
According
stand.
to them, you have
Para
not
6.
availed your alternative remedies.
My Lord.
They are
In para 6 also, there is no such objection at the time of acquisition, if any, my Lord. Probably that line is
And
also
my Lord, the
there.
ground in para 6, they have taken a ground
Because
of
they have come after almost
hostile-
29, 30 years.
My Lord, in these cases also, my Lord, the Honorable Apex Court had
That
interfered.
is right, my Lord. Well, one property has been taken away, then obviously, my Lord, they will get the compensation.
My Lord,
Point
limited
of delay
prayer
is
is that
also
let
there,
the, my
my
Lord,
29 years, that is true. Admittedly, this land is under the physical possession of CRPF since 1975.
yes.
And you have approached this court in
My
2014.
Lord, in this, my Lord,
There have been
my Lord, in the Tukaram case,
is
and
on
in-
your part as well,
yes,
Mr. Das.
that my Lord, aspect of delay and laches has also been, my Lord,
Explained.
dealt with in this 2020 Vidya Devi's case, my Lord.
Those decisions are rendered in the
Yeah, my-
context of
Context.
those
So
cases.
that is why, and my Lord, so therefore, my Lord, my limited
Will not give you a
Read it from
liberty.
facts to facts, my Lord. to my
from
knowledge.
their record, from the record of the state, my Lord, which it is there. It says that, my Lord, the CRPF is in unauthorized possession, and our
Yes, CRPF. Ms. Gayan, you've been very silent.
No, ma'am. There in paragraph, page 5, paragraph 6 of our academic.
I have paragraph 6
Yes, madam.
open.
And 16, and we have also acquired under acquisition order number KRC PXI 6/7 31/1975.
There is an order.
There is, and we have mentioned that also, madam.
Lord, that
This paragraph.
In paragraph 6.
Under acquisition order number so and so dated 31/3/1975.
Yes,
What
madam.
is this?
Madam, for that we have write a letter to circular officer, that is page 35, madam.
Records are not available.
Yes, madam.
They have not produced anything, they cannot, and we are. our
Page
office is-
35 of?
A writ petition.
Okay, a case also has to be dealt with from the humanitarian aspect, correct?
Yes.
Now, Because without saying much, it appears the land of the petitioner is in the possession of CRPF since 70.
Yes.
If you have followed a procedure prescribed under the law and you have paid adequate compensation to the owner, no problem. But without doing that, you cannot be retaining this land. You have to follow a procedure, number one. Number two, if the land belongs to the petitioner has to be adequately compensated. You cannot simply acquire the land of the petitioner and not compensate, correct? So you have to satisfy this court on those two aspects.
Yes, ma'am.
Because admittedly, petitioner's land
Yes.
or somebody else's land, whatever be it, land is under CRP, the subject
That
land.
is, yes, that is,
Correct?
yes.
That is there. Now, after that, what have you done? Where are those documents? Because your paragraph 6 is saying that it has been done as per procedure,
Yes,
but
ma'am.
petitioner is saying, but the circle officer's report says there is no procedure followed.
In para 8 of our affidavit, my lord, we are also admitted that there is no such availability of record, my lord.
Whatever be
So
it,
it is,
from
right
an
now it is
affidavit,
ascertain whether
it
any
is
process
another
is done
thing,
or
but
not.
the report itself is before this court. This court cannot ignore the report of the circle
They
officer.
can verify
And that joint survey report are also there. Now all these are indicative of the fact that the petitioner's land is under the possession of CRP. Now if compensation has been paid, there was no reason for the petitioner to approach this court.
Madam, for that, madam, my humble submission is that as per the circle officer report, that is page number 31, my lord, here they have stated the name of the pattadar, my lord. So without making him party, who can, my lord, say that whether land compensation has been done or not, my lord? Kindly see, my lord, these are the pattadar as per circle officer report, my lord. Page
Lord,
number
we are
31.
we are not concerned with the other pattas.
49 is
49.
Yeah.
49.
But in 5 and 49, my lord, come to the last paragraph. As per available record, following are the recorded pattadar in respect
Yes.
of.
Charlene is there, Cressida is there, and
But they are not
three are there.
petitioner. No, madam, they are not.
No.
These are the three petitioners, 1, 2, 3. Correct, Mr. Das?
Yes, my lord. And number 4, these three have so.
They have sold. Yes, you have shown me.
Lord, we are concerned with 5 and 49. We are not concerned with the other lands. So, yes,
Ms. Gayan, I don't think there is any dispute to all that. But in any case,
yes. And regarding
title to inquire everything,
Yes.
isn't it? If something, it appears an inquiry is also done. That joined the document at 37 and the document at 47, the joint verification. You see, in joint verification also it has been said the three petitioners' names have been given.
yes.
Dag number 49 and dag number
5 and 49.
page 47, Ms. Gayan.
Yes.
47.
7 is also.
It was done in the presence of CRPF, and it has been written down that however the officials of CRPF refused to put their signatures.
Yes.
Yes,
Madam, here,
what is to be done? We need to fix this.
yes, madam.
On the
What
basis
day?
of this joint verification and reconsideration can be done. That much we can say because no such record is available.
Yes.
If court also asks to direct the produce the record, probably it will help minor because we are not.
Lord, the joint
Yes,
records are
verification.
not there.
One thing, Ms. Borman, now under which act compensation has to be given?
You understand.
For
Right
that
to
reason,
fair.
we need to verify the record, whether it is LA 13 or
Right
it
to
is
fair
under 64
compensation.
Act.
This
I
is
think
under
it's
this.
No, but this has been
been verified. by the-
14, my lord. Now
Just
their
only-
submission is, my lord, they will do verification and all those things.
Mr. Das, admittedly this land was taken in 75.
75.
Yes.
How will this come? Because the acquisition proceedings have not started. That provision you are relying.
Yes, my lord. No. This old act has been repealed. Now this, my lord, this right to fair compensation and this act will govern, my lord.
No, in your case it will govern.
It will cover because
correct?
yes.
In any case, my lord, any land acquisition process, nowadays compensation are given as per section 26 to 31 of the 13 Act, my lord. Whether it is state acquisition or it
Section?
is section 26 to 31, that one calculative formula is there. On the basis of that, and there are standing orders from the revenue department also, my lord, that compensation has to be
Can
as per
this
those
writ petition be disposed of with this direction that
They can verify on the
upon due
availability of records.
Yes,
verification,
madam.
the respondents shall pay compensation to the petitioners in accordance with law?
That can be.
My
Simple
lord, before, my
disposal.
lord, yes.
And we, a time frame.
You will be
Yes.
Yes, my lord, before that,
you do it if they are entitled in accordance with law. You proceed.
one line may be observed, my lord, that that KRC's number that may be charged by them, but we have stated one number of that acquisition order number.
No, I'm not getting into that because you see the
Saying, my lord, she is referring to one that Karachi
Yeah,
letter. It is
whatever,
in the
that
writ
is your
petition only.
thing. I am not going into all that.
Yes.
But the circle officer's report indicates clearly there is no procedure adopted.
Yes.
So, anyway, we are not getting into all that.
Yes,
In
my lord, yes.
para 10 of our affidavit, we have clearly stated that that acquisition order, as mentioned by my learned son, it is not found.
Not
So we
found,
cannot
madam.
provide in a position to provide them also neither to the
All right.
petitioner. my lord.
Because Lordship has seen that the circle officer has already given a report regarding joint venture.
Take your
They
seats
will,
now.
my lord, make a survey. Yes,
Let me dictate the order.
Yes,
If
ma'am.
there is any editing required,
Yes, ma'am.
Yes, my lord.
you can assist
Yes.
after the order is dictated. Heard Mr. A. Das, Learned Counsel for the petitioner. Stop. Also heard MS
I am for
M. Borman,
respondent number 1.
Government Advocate for the State Respondent, and MS A. Gayan, Learned
CGC for respondent number 1 and 2.
Respondent number 1 and 2,
Yes.
and Mr. A. Bhattacharya for respondent number 3. Stop. By way of the present writ petition, the petitioners are seeking direction inter alia due compensation on account of use of the petitioner's land by the respondent number 2, by the respondent number 2 since the year 1975, and or to initiate necessary land acquisition proceeding in accordance with law for acquiring the petitioner's land. Stop. The facts of the present case is that the petitioners are the joint owners and recorded pattadar in respect of land measuring about 50 bigha of village Sarutari, Mauza, Sonapur, district Kamrup, Metro, Assam. Stop. Out of the total land measuring 50 bighas, a portion of land measuring about 5 bighas, 4 lechas, have been in forceful occupation of the CRPF since about 1975, wherein the CRPF authorities have constructed their water pump house, the occupation of the CRPF, at 9th Mile. The petitioners had been repeatedly approaching the CRPF authorities for vacating and handing over the peaceful physical possession of the land to the petitioner, or to initiate acquisition proceeding for payment of an appropriate compensation to the petitioners in accordance with law, but the same failed to bear any fruit. Stop. Upon joint verification by the Circle Officer Sonapur, it was found that the CRPF authorities are in illegal occupation over the petitioner's plot of land. Stop. Though the CRPF authorities could not submit any proper legal document in respect of the possession over the petitioner's land, but even then they have been occupying the petitioner's land without any lawful authority. Stop. The concerned authorities have not taken any action till date, either for returning the plot of land to the petitioners, or for purchasing the same, or for initiating land acquisition proceeding for awarding compensation to the petitioners for acquiring their land. Stop. Accordingly, this writ petition has been filed. Heard the parties at length. Stop. Next para. It appears that the circle officer, Sonapur Revenue Circle, Sonapur, by inquiry report dated 21/11/2012, came to the findings hereunder. 1, 2, quote unquote করে দিব একদম দুখন পেজ page 37 and 38 মই ইয়াত টিক মাৰ্ক কৰি দিম till the last part. Next para. The aforesaid inquiry report is abundantly clear that as per the revenue records available, there is no record of any order of acquisition or compensation of the said land used as water pumping house station by CRPF or paid any compensation to the original patta holder, i.e. petitioner number 1, 2 and 3. Stop. It further clarifies that the petitioner number 1, 2 and 3 are the owner of the said land which is occupying by CRPF by putting water pumping house station since the year 1975. Stop. It further appears that a joint verification of the subject land was carried out on 28/2013 in the presence of the CRPF authorities and jurisdictional mandal of the land acquisition branch. Stop. A perusal of the aforesaid joint verification report indicates that the subject land were found to be in possession of the CRPF since 1975, and the recorded pattadars of the subject land covered by DAG number 5/49 of patta number 31 are the petitioner number 1, 2, 3 respectively. Stop. Correct, Mr. Das?
Yes, ma'am.
Pertinent to mention that the state respondent in their affidavit in opposition where is your affidavit? R4.
R4 is my affidavit.
In the state respondent number 4. In their affidavit within bracket, respondent number 4 within bracket, who is R4?
Deputy on behalf of Deputy Commissioner.
Deputy Commissioner Kamrup.
Kamrup Metro.
In his affidavit filed on 12th January 2016, which Which was the paragraph? Ms.
Relevant
Mohammed?
paragraph is 5,
Last portion.
8 and 10.
Has also stated that as per
Para 5 last.
as per record and the joint inspection conducted, comma, CRPF is in possession of the land at Dag number 49 and 5 of the Patta number 31 since 1975. Stop.
Para 8, 5th line, 6th line, my lord. Is stated that
Paragraph 8 of the aforesaid affidavit is reproduced hereunder for ready reference. Page 68 on power, paragraph 5. Huh? Paragraph 8.
10 also.
And 10. Paragraph 5, page 67. Paragraph 8, page 68. Paragraph 10, page 69. Are quoted hereunder for ready reference. Pertinent also to refer. Yes, CRPF's affidavit.
Yes, ma'am. In paragraph 6, my lord, page number 5.
Paragraph 6 of the affidavit in opposition filed on behalf of the respondents number 1 and 2 within brackets CRPF authorities on 16/12/2014.
Yes, ma'am.
Itu page 60 power quote kori diba, paragraph 6. Okay. Then you. It is thus evident that though the CRPF authorities have stated in their affidavit that an acquisition order is there, however, no such order has been placed on record by the said authority. Stop. In fact, it is the categorical stand of the state authorities that no acquisition procedure has been no records of acquisition proceedings in respect of the subject land is available in the records of the office. Stop. The report of the circle officer dated such and such and the joint inspection report dated such and such is indicative of the fact that the petitioner's land is under the possession of the CRPF authority since 1975. Stop. The specific grievance of the petitioner is that the authorities, without following any procedure, has illegally taken the aforesaid land of the petitioners under their possession and has also not paid any compensation till date. Stop.
Madam, one observation may be made. Madam, page number 36 of the petition, one annexure is there regarding the certificate of possession of the land, Madam. 36, Madam.
What is this?
That is the handover and taking over of the land, my lord. And their report is, my lord, they have stated in page number 38, my lord. That may be said. Page number 38. They have a last line. But in the said certificate position, handing over and taking over land, no Dag number and Patta number was mentioned, my lord.
Where? In
Page number 38, my lord. First paragraph. Last line. Second line, my lord. That may be observed. Page number 36 and type copies page number 35A.
This relates to some other plot of land because this total land was given is, my lord, 14 bigha, 1 katha, 1 lechas.
So what is this document at 36? This is your document, Mr. Das.
Yes, my lord.
What is it?
This is, my lord, what has happened, this CRPF, where it is situated, they were allotted a land that at page 35, lordship will find it, this is the type copy, my lord.
Yes.
My lord,
Yes, yes.
yes, so they are saying that 1975 the subject land was acquired and given to them. Now in 75 what was done, the total land, my lord, measuring 14 bigha, 1 katha, 1 lecha was acquired and given to them, but that is not this covered by tag number 5 and 49.
5 and 49.
Yes,
That
because
is
it
on the
says,
page number 38.
This is in respect of some other DAG number.
yes, some other tag, because
The
it says
number
that,
is not stated in this certificate, my lord.
yes, it will not be stated because it was not handed over. At page 35A, lordship will see 1, 2, 3, 4th line, KP's land. The possession of KP's land, lordship got it, my lord? Possession of KP's land measuring 10 bigha, 1 katha, 12 lechas of Sarkari land measuring 1 bigha, 2 katha, 3 lechas of village, so and so, so and so.
Anyway,
And
I think
so
this is not required.
Not required, my lord.
কি লিখিলা লাষ্টত? The apex court, in the case of Tukaram Kana Joshi and others, reported in 2013, volume 1 SSC at page 353, have stated that in a welfare state, statutory authorities are bound not only to pay adequate compensation, but there is also a legal obligation upon them to rehabilitate such persons. And depriving a person of their immovable property is a clear violation of Article 21 of the Constitution. Stop. In the present case, it appears that the petitioner has been deprived of its land since 1975. Has been deprived of their legitimate dues since 1975. Stop. It further appears that this court, in the case of Sri Sasanka Kumar Datta versus State of Assam, in WPC 4378 of 2008, by relying on the decision of the apex court in Tukaram within bracket Supra, allowed the writ petition by directing the authorities to pay just and proper compensation to the petitioner in terms of the provisions of the Land Acquisition Act. Stop. The apex court, in the case of State of Himachal Pradesh versus, in the case of Vidya Devi, Vidya Vidya Devi versus State of Himachal Pradesh, reported in 2020, volume 2 SSC at page 569, has held that in a democratic polity governed by the rule of law, the state could not have deprived a citizen of their property without the sanction of law. Stop. In this case, admittedly, the petitioner's land has been taken over by the CRPF authorities way back in 1975 without following any due process of law. Stop. Further, the petitioners have also been deprived of their legitimate dues in respect of the aforesaid land. Stop. Be that as it may, without going into the merit of the allegations level, this court is of the considered view that it would be that in the ends of justice, this writ petition can be disposed of by directing the concerned respondent authorities.
Well, respondent number 4 in particular, because it is the deputy commissioner. Otherwise,
Respondent number 4 to cause an inquiry into the matter, and if the petitioner is entitled for any compensation, comma, upon due verification, the same shall be paid thereof. Is that all right?
yes,
Yes.
then exercise shall be
I will say that. Needless to clarify that the respondents in the concerned departments shall cooperate with the respondent number 4 in order to finally settle the claim of the petitioner. Now, needless to also clarify that the aforesaid exercise shall be completed within a period of
6 months.
6 months.
6 months from the date of receipt of the certified copy of the order.
By the respondent number 4.
That I have already indicated. Mr. Das is very generous to the government.
No, otherwise, my lord, they will keep
With
on
the
playing.
aforesaid observation direction, this written stand disposed.
Our hands are tied due to loss of record. Yes, that's the thing.
No, but you see, there is no point of keeping a 2014 matter
Yes,
pending.
yes,
If the petitioner is entitled, you cause an inquiry and you give them whatever is to be done, you do it.
75 order says acquisition,
Yes,
but we don't have any papers.
Well, only one observation.
But
Report says so.
see, if the CRPF is under the possession, there must be something. Now, if there is nothing, then they have to give the possession, because admittedly from the circle officer's report, they are the pattadar. So you have to pay them something. If your office shows that someone has been paid, then that's a different thing.
My lord, only one observation. The petition was filed by the power of attorney holder of these two sisters. My lord, I am told that the power of attorney holder has expired. Now, to that extent, either the petitioners themselves or through someone, otherwise in the cost title, if it is reflected, then again we'll say...
Das, you should have made that submission in the
Before
beginning.
that,
Only, my lord,
Whole exercise we
Sufficient judicial time has been invested in
only, my
this
lord,
matter.
that...
no, in that case, my lord, if
whole matter will be
other person without any authority, my
Well, the
lord,
petitioners will do, my lord. Now,
Petitioner,
because in the cost title, they will just copy from this, in the order sheet, my lord. It will be, my lord, whatever is written there, that will be copied, my lord. Now, if the authorities, my lord, want to delay,
on his name, my lord.
yes, madam. By
the
power-
petitioner themselves or, my lord, to the other, my lord, attorney Vincent Stone Shelia. I am told that, my lord, he has expired, my lord, during the pendency of this litigation. Page 3, my lord, lordship will find, my lord.
Yes.
Affidavit is sworn by Vincent. He has gone.
attorney holder.
No, he has gone means during his lifetime it has been sworn. He has not sworn after
The
death.
moment he
So
dies,
Das-
it has to be notified.
During the
Something, Mr. Das, then either the petitioners has to come on their own and put a, and otherwise how do you how can this order be valid? The power of attorney holder has already died.
But that is why I am saying, Malad, just an observation that my submission may be recorded. This power of attorney holder has, as he has expired, my lord. Now that this power of attorney holder cannot be used. So either the petitioners themselves or through some other
Thus,
attorney.
this should have been submitted at the beginning. Very sorry, sir, state of affairs. Cancel that order. You cannot pass that order because you'll have to make the necessary changes. You have to come by way of an application, file an amended cost title. Yes,
Well, at there, my lord, when the petition was filed, he was here.
that is different. But today, at the that attorney holder is not there.
Well, my lord, the benefit will not go to the attorney holder.
That is not the question. Who is representing the petitioner here?
My lord, the petitioners will themselves.
Where have you stated that? Where is your application to that effect? This is you're making this court pass an order in a petition where the power of attorney holder has already expired. And who's representing the petitioner? The petitioners are not representing themselves in this petition.
My submission is that at the time of filing of the yes.
Mr. Das, you
During
are
the pendency
not understanding what this court is
Yes,
saying. If the attorney holder has in the meantime expired, then
Yes.
you make alternative arrangements, simple and short. Once you make that arrangement, you will get the order. But without,
Then, my lord, the petitioners, they will verify, and if the petitioners are entitled, they will be.
Mr. D. Das, learned advocate for the Mr. A. Das, learned advocate for the learned counsel for the petitioner, submits that the power of attorney holder, i.e., what is the name?
Vincent Stone
Sri
Shrelia.
Vincent Stone Tolia
Sure.
has expired in the meantime. Stop. Stop. He accordingly seeks accommodation. He accordingly seeks some accommodation in the matter to make necessary application in this regard. List 2 weeks for which media time. This is not expected from the bar. These are information you must say in the beginning.
Because
Wait, next matter,
ultimately, my lord, these benefits should go to the, my lord, petitioners. only.
Last
That is-
technicalities are
File-
there.
File necessary applications.
You must inform the bench before you proceed in such kind of a situation.
I'm sorry.
May I please, your lordship. My lord, advocate for the petitioner, Mr. P. Burman, my lord. Advocate for the petitioner, my lord. Mr. P. Burman is not available in the court due to his tooth problem.
Huh?
And she is not available in the court due to his teeth problem, my lord.
Due to what problem?
Tooth pain,
Dental problem.
dental problem, my lord. So, my lord, so that may be fixed.
Advocate
P. Burman,
MSP Verma.
MSP Burman.
Her name is at the last. There are 5 names on top of her. Where are those other advocates? Who are you?
I am SK Singh, my lord.
Your name is also there.
My lord,
Then
she is a senior, my lord. She lead the case.
how come the senior's name is down? It is submitted that MSP Borman Learned Counsel for the petitioner who is conducting the matter is indisposed due to a dental issue. Stop. Accordingly, stop. List this matter due to after time later. On so and so. DDF. Yes. Yes, Mr. Borwa.
Lordship, item 12 to 17 are analogous. Lordship, in similar set of legal point, the Tripura High Court has decided the issue in favor of the writ petitioner. Against that, the state of Tripura went to the Supreme Court by way of filing an SLP. Lordship, pending, and it is listed today for hearing, Lordship.
All right. It is submitted by Mr. P. Borwa that the issue involved in this writ petition are pending before the apex court in
Lordship, I have given the
Rupa. In SLP within bracket C number 006469 stroke 2018.
Lordship.
Stop. He further submits that the aforesaid matter is listed before the apex court today. Stop. In view of the above, cyanide or what?
2 weeks, Lordship.
Lordship, let it come after 3 weeks. In the meantime,
In view of the in view of the fact that the issue involved in this writ petition is pending adjudication before the apex court, this court is of the considered view that this writ petitions be adjourned sine die with liberty to either side to inform the registry as and when there is any development in the matter. Adjourned sine die. What is the point of listing it after 4 weeks? That week also you will come up and say the matter is pending. There is a lot of effort has to be made at all levels in the High Court for listing these matters. Then judicial time is unnecessarily also wasted, right? If there is any movement, you come and inform. Cost the
May I please, your lord.
My Lord, this petition has been filed by the wife and minor daughter of the deceased, seeking, my Lord, compensation arising out of custodial debt. Custodial debt, my Lord. Here in this case, my Lord, I would like to point out to Lordship whether the deceased died due to negligence of the police activities, my Lord.
Affidavits filed?
Yes, affidavit filed, my Lord. Affidavit filed by respondent number 6 and 7. My Lord, now Your Lordship kindly see, initially, my Lord, there was an allegation against the deceased that he took away two numbers of cylinder from another house, my Lord. Your Lordship, page 11, Your Lordship kindly see the FIR, my Lord. May I read, my Lord, vernacular portion, my Lord?
Yes.
Vernacular portion, for page 14, my Lord.
Page?
Page 14, my Lord. This Azahar was lost by, my Lord, one Nipun Nath.
According to you, sir, adequate medical treatment
Yes, my
was
Lord.
not given
Not
to
given,
the
my Lord. Not given.
delinquent, to the what happened, my Lord? He was apprehended. First, he was apprehended by public. He was beaten. Immediately beaten. After beaten, he was handed over to the police. It was the duty of the OC or investigating officer. Since he was beaten badly, immediately he should be taken to the medical for proper medical treatment. Not given. What happened, my Lord? Next day he medical treatment at all not given. Next day he was produced before magistrate, local magistrate. Magistrate is strictly ordered, observing his physical condition, adequate medical treatment should be provided. Where is that?
Not given.
Where is that?
Yes, my Lord, I am not given. Next day, my Lord, he was admitted in the hospital. In the meantime, died.
There has been some delay.
Yes, my Lord. Your Lordship kindly see.
What is your stand?
I mean, there is no such medical negligence, my Lord.
Why?
Because he has proper medical treatment has been given, my Lord.
From where are you showing that?
Yes,
because there has been a delay in taking him to the hospital. How have you ever...
On the same day, my Lord, he was given judicial custody on 21, my Lord. On same day, my Lord, medical treatment was provided, my Lord. 21/9, my Lord.
May I please?
21/9?
16, my Lord.
16?
Yes.
Judicial custody.
Yes.
And when was he taken in police custody? Mr. Gogoi, you are in this matter?
On 20th.
On
20.
20.
Paying up, my Lord, kindly see your paying up for their petition, my Lord. Police took the custody on 20, my Lord. On being caught by nearby people.
Paragraph?
Paragraph 4 of the lead petitioner.
Yes.
Yes.
Petitioner explained that the investigating police took into custody of the victim Gopinath and Sahadev Nath on 29/2016 on being caught by neighbor people, and thereafter on 21/9 both the said arrested persons were forwarded and produced before the Planet Sub-Regional Judicial Magistrate Metro Blasipara without proper treatment. Thereafter on production, the Ranet Judicial Magistrate passed specific order on Iman. On that day, my Lord, we put him in the, my Lord, jail before the jail superintendent, my Lord. Jail hospital, my Lord. We have some documents, my Lord, but that documents has not been, my Lord, annexed to the
Let's do
petition.
it like this.
Yes.
I'm posting this matter on Thursday. Give me a brief list of dates
Yes.
of the sequence. And on that day, you may also do it. Both sides can, just a list of these
My
dates,
Lord,
the crucial dates. Alright?
On 16, my Lord.
You have some difficulty?
My Lord, on 16.
Due to paucity of time, this matter could not include.
But, may I be on 10th, my Lord?
10th?
No, 17. 17. 16.
16, okay. Give me a list, just gist of the sequence of those dates.
Obliged, my lord.
Please, your lordship. Lordship, conducting council Mr. P.P. Bordhakur is out of station due to conducting council P.P. Bordhakur due to some medical emergency of his
It is
father.
submitted on behalf of on behalf of the petitioner that Mr. P.P. Bordhakur, learned counsel appearing for the petitioner, is out of station due to medical emergency. Stop. Prayer is who is for the other side in item 19? None appears for the respondent when the matter is called. List after.
Next week, lordship, any date?
2 hafta episode data then.
7. Lordship.
Yes, next. Police security coverage. None appears for the petitioner when the matter is called.
And we have filed affidavit also. There is no security specific threat is there also.
Threat prospection is not there?
Nothing is there also.
Where?
We have filed affidavit also.
Where? Page?
Page lordship. One is filed by the lordship. Additional SP Security SB lordship. Budindranath Morang.
Page 14.
Page lordship CL running page we have not. Page 2 lordship.
Of the affidavit in opposition?
Not action. 34 losses. Running page only 34.
34?
34, it will be 35 losses.
34 is an affidavit in reply.
That is missing. That is also missing in the file. In the first file, that affidavit is not there.
Just point out that affidavit, because if there is no third threat perception, then probably I can dispose of this petition.
Otherwise, lordship in page 28. Page.
Flag it there.
It is not there. No. Blue color.
Why it is there?
I tried to my serial number because it's difficult.
I can get. I said a whole league. Yeah.
Person? Second.
Yes.
Paragraph 7, lordship. Seven and 8, lordship. 7 last para, lordship. Last line. The Superintendent of Police Kukrazar.
Yes. Then how will this court go into this aspect? Because the report is clear.
Even report is also there in paragraph 8. It says that, lordship. Even against the petitioner, police case is pending, lordship.
Heard Mr. K. Gogoi, learned additional senior government advocate. Anybody else? For the state response. By filing the instant writ petition, the petitioner is seeking restoration of the all-round protection as provided earlier the petitioner. Stop. All-round security, all-round security protection. Stop. Mr. K. Gogoi, learned additional senior government advocate, draws the attention of this court to paragraph 7 and 8
and
of
9
the,
also,
and 9 of the affidavit in opposition filed on behalf of respondent number 4.
And another one is, lordship, filed by respondent
On
number 7.
11 10/2018. Stop. Paragraph 7, 8 and 9 of the aforesaid affidavit is reproduced hereunder for ready reference. Etu mark kori disu tomak ha. Which is the other affidavit?
Other affidavit filed by respondent number 7 Lordship. It starts from page 28 Lordship. Page 28 Lordship.
Page
28, running page Lordship.
Of this file, the blue file?
First file Lordship. Beleg file house
Page
28, running page Lordship. Starts from page 28.
He further draws the attention of this court to the paragraph?
Paragraph Lordship 7, 9, 6, 7, 9 and 11 Lordship.
6, 7, 9 and 11 of the affidavit in opposition filed on behalf of respondent number 7 on 14/8/2018. A yellow flag marked with A. A perusal of the aforesaid paragraphs stroke averments indicates that upon reviewing the threat assessment in respect of the petitioner, the IGP BTAD Kokrajhar reported that there is no specific threat as regards the petitioner, and accordingly the security cover earlier provided to the petitioner was withdrawn. This court finds no illegality as regards the withdrawal of the security cover provided to the petitioner in view of the threat assessment made by the respondent authority. Accordingly, this writ petition is dismissed.
Very good.